folks. Looks like we are live. I'm George, founder of Solo, and we have with us here today Ben Jackson, my friend from
Hello, hello.
Upsolve. Can you go ahead and tell us a little bit about yourself, Ben?
Yeah, hey, George, thanks for having me on. So, my name is Ben Jackson. I'm the co founder and chief product officer of a nonprofit called Upsolve. And what Upsolve does is it helps people break free from debt so that they can get closer to their American dream. And the reason that I started this company is because I personally, about 9 years ago, had $60,000 in credit card debt, which is a lot of money for anybody. It was especially a lot of money for me because I was only making $20,000 a year driving for Lyft, Uber, Instacart, et cetera. And I could not make any progress on that debt. I was really ashamed, right? Like I had put in a ton of work and this is all I had to show for it. And I was especially ashamed when I ended up on food stamps. Like that's how bad it got trying to pay the interest on these credit cards. I was kind of stuck in a rock and a hard place and I really felt no hope for my future until one day I discovered something called Chapter 7 bankruptcy, which is a legal process that makes it really simple for people who have fallen behind for whatever reason. Data shows usually the reason is a medical emergency or some sort of unplanned life event that just results in a ton of expenses, as it was for me. It's a legal method for those people to get out from under that debt and get a fresh start. So I did everything I could to try to figure this process out. I spent like, I don't know, way too long, 6 months trying to get like every form from every possible site to the point where I had like stacks of paper on every surface of my house. And then finally one day had a completed bankruptcy petition, took it into the court, dropped it down, and then 6 months later got a piece of paper back saying that that debt was gone. It felt amazing, and it left me with two realizations. One was, wow, I want to help everybody do this. And two, why the heck was this so hard? It should be easier. So I went to law school with the express purpose of trying to figure out how to make that legal process easier to access so that more people could break free from debt and really realize their American dreams. And then in law school, co-founded Upsolve to help people do that bankruptcy process through a TurboTax style workflow. So today, if you go over to upsolve.org, you can launch our tool. You can answer some simple questions, TurboTax style, for those of you who are familiar with that, and get those forms at the end of the process with detailed filing instructions 100% free. And we've helped over 16,000 people get out of over $730 million in debt and add $1.2 billion to their net worth. So something that really works and something I'm really proud of.
Oh, that's fantastic. Love that. So you yourself are a bankruptcy success story.
Yes, I am. And there's tons more like me out there. I'm on a mission to kind of destigmatize bankruptcy because I think it gets a bad rap.
Nice. So you went to law school with somewhat
Mhm.
of the express purpose to fix or bankruptcy or make it easier.
Yep.
When you're in law school, people usually ask, are you doing contract law? Are you doing civil law? Would you just say, I'm going to reform bankruptcy?
Yeah.
Was that what your
Well,
answer?
it's a funny question because I think like it. I knew that I wanted to help people better navigate the legal system, and I couldn't find a way to fit that into those categories, right? Because like everybody in law school is like, I want to be a Supreme Court justice, or I want to be a multimillionaire, like big law partner. And so my lane was kind of what's called like legal tech and automation, sort of like an emerging area of the law that says like, how do we take these processes and make them less manual, make them easier for people to approach. And so I was kind of a weird loner in law school, which is probably no surprise to people that know me.
Yeah, right. By emerging, you mean there's maybe one person at each law school that is interested.
Yeah, exactly. Yeah. It's 100% right if they're lucky.
Yeah, no. It sounds like me. Sounds like me. I
Yeah.
had the
Yeah.
same experience in law school, right? I'd usually say, well, I'm going into legal tech. People are like, what? What are you doing? What is
Yeah.
that?
No, it's a real thing. Not really a word that you can tell your in-laws and they're happy with it.
Right. Indeed. Well, that sounds great. So today, we answer questions that you might have, right? So if you're on the show live, which many people are, a lot of people here on the webinar, just go ahead and put your question into the chat, and then someone at Solo might respond to your question there on the chat. Also, we'll be trying to take your question live when we get to it, so we'll try to resolve that or answer that question hypothetically. And we also are going to be talking about how to file bankruptcy without an attorney
Mm.
as main topic for the webinar. just
So
a precursor disclaimer for everybody. We are not your lawyers. Solo is
mhm.
not a law firm. Upsolve is not a law firm. We're just doing a webinar here. We're not providing legal advice.
Yes. And I'm noticing in the chat, a few people have said they can only hear me. Some people said they can hear everybody. So I guess we can kind of like back and forth. I'll repeat your questions or your answers in some or something for those that can't hear. Sorry about that, guys.
Let me try headphones, actually.
I can hear you fine. So volume is low.
Okay, great.
There we go. Much louder.
Let's see if everybody can hear me now.
I promise that we are actually tech companies, everybody. We can figure this out.
It seems like no matter how good you get, tech is always.
I know.
The AV stuff, all AV stuff,
I know.
always trips people up.
Impossible. Cool.
Because it's always changing, As soon as AV figures itself out, then it changes.
I know, 100%.
Right. Okay, great. Looks like everyone's hearing me better, so that sounds great. So let's see. So on the topic of filing bankruptcy without an attorney. So Ben, a question that we are hearing quite a bit is how do you know if responding to your debt lawsuit is the primary concern, or if you should file for bankruptcy first?
Yeah, it's a great question. So you should always respond to any debt lawsuit that you receive. Like as soon as there is a complaint filed in the court against you and you get notice of that, you should respond to it. Because the risk of not responding to it is that if the case proceeds, you don't show up, you don't have any documentation filed in your case, that the court could enter what's called a default judgment against you, which means basically like you lose by default because you didn't respond. And so you always want to do that answer first, and that's something that Solo can help with. When it comes to bankruptcy versus settlement first, which is sort of like a separate question, which is like, do I engage with this lawsuit beyond answering first, or do I file bankruptcy and stop this lawsuit? It's important to know that like one, bankruptcy almost always does stop debt settlement law or debt collection lawsuits. However, it depends on the stage in the process that you're in, which I think George can speak to a little bit better than I can because he's the expert on debt lawsuits.
Right. So you're saying if somebody is sued for debt and they have probably a lot of debt and they're considering filing for bankruptcy, you're saying they should first file for the response to the lawsuit, right?
Yep.
Exactly. Yeah, but that's right. And then after that, they can file for bankruptcy. Bankruptcy does put a stay on the lawsuit. However, there's always a risk that the bankruptcy won't go through, that it might take a while, that the collections lawyer suing you might be particularly fast, the court might go fast. So if you don't respond, then you could end up getting like your wages garnished before you ever even file for bankruptcy and there's a stay placed.
Yep.
Once your wages are being garnished and you file for bankruptcy, there will be a stay as well.
Yeah, it depends on the type. It depends on the type of wage garnishment. Like if your wages are being garnished for, say, like unpaid child support, the bankruptcy is not going to impact that because those things are not dischargeable. If you have wages that are being garnished for collections, that wouldn't happen unless there was a judgment against you. So it really it depends. I know that's not a clear answer. We have some articles on upsolve.org if you want to take a look to get the specifics for your situation for the various types of judgments. Suggest just Google upsolve.org bankruptcy and judgments, and you'll find an article that answers that question in more detail. I hate giving an "it depends" answer, but that's often the case when it comes to these things.
Yeah. Well, and I think the answer for most people is that bankruptcy will probably stay the garnishment.
Yep.
If you're being garnished for like pretty normal stuff, you'll probably stay that.
Yep.
Great. You might have to enforce, as with anything in the law, you might have to enforce that yourself. Like you might have to patrol and make sure that the garnishment actually does stop, but it should likely stop. Great. So, what's the best way to file bankruptcy without an attorney, Ben?
Well, I would say Upsolve, but we never want to put ourselves forward as the best. We have been the option for over 16,000 people. More than 90% of the filings that we work on ultimately get approved, and we have thousands and thousands of people that have at least gotten educated on the process. So you absolutely can do this by yourself, assuming that you have a simple case. And simple means your income's not very high, your debt is really high, and you don't own expensive property. And our tool at Upsolve can help you figure out if that's the case for you and if it's safe for you to file on your own versus if you should work with an attorney, which we can make a referral out if that's the case.
Fantastic. Yep, and we refer people to Upsolve ourselves. So if you're looking for bankruptcy, can certainly be a great option, and I think very likely the best option for a lot of people.
Hmm.
That's for sure. So great. How long does bankruptcy last?
There's two pieces to this. One is how long does it last? The other is how long does it stay on your credit report, which is what people are often wondering about. So a bankruptcy proceeding usually lasts about 6 months. I've seen them go through as fast as 3 months, and it does kind of depend on how complex your case is. So, for example, if your case is standard, you only have credit card debt, you don't have really any assets. Everything in your filing is covered by exemptions, meaning the trustee is not going to take any of your assets. And you aren't trying to take some loan through the process, meaning like a car loan or something like that that you want to keep afterwards. If that's the case, I've seen it go as fast as 3 months, but the average is about 6. Um, if you do a reaffirmation, it usually adds like another month on. And without boring everybody, that basically just means I have a car, I have a loan on my car, I want to keep that loan and the car after the bankruptcy. And so I have to get the judge to give me permission. That will add like another month to the process. The second part of the question, which is like, how long does this matter on my credit report? I can kind of answer from personal experience. So you're going to take a hit if you have decent credit. It's like if your credit is pretty good, you're going to take a pretty significant hit. If your credit is really bad, it's probably really bad because of bad debt. And when you file bankruptcy and that debt goes away, I see lots of users whose credit goes up immediately because that bad debt is gone. The filing itself will stay on your credit report as a negative record for 10 years for a Chapter 7 filing. But from personal experience, I was able to repair my credit enough to get a mortgage with a good rate at about the 7-year mark post filing. So it definitely doesn't by any means ruin your life financially, especially not as much as bad debt that you can't pay would.
Fantastic. So proceeding is about 6 months,
Mhm.
stays on your credit report 10 years.
Yep.
What if you do something crazy like get a new loan during the proceeding? Like
Yeah.
you're buying a chair at the furniture store and just have to get that financing.
Not a good idea. That is potentially a way to get your case thrown out. Good luck getting that loan because as soon as you file, the filing is going to show up in your credit history. So there's like an open inquiry. Your creditors are noticed. It would be very difficult to get a loan while in your proceedings. But if you did manage to do it, it would be bad for your case. So my recommendation would be if you're trying to get a discharge from your debt through bankruptcy, just wait till the proceedings are over to apply for any loans.
Great. We have one person in the audience who said you can start getting conventional home mortgages for FHA after about
Mhm.
2 years
Yep.
after bankruptcy. Does that sound about right to you?
Yep. Sounds about right. Anything that, yeah, it's great point, Brian. You do have to rebuild your credibility in that time. So what I was referring to with my like 8-year experience was I was in standard rating categories around there. So it didn't really impact my creditability at that point. You can definitely get loans that are designed for lower credit or no credit situations like FHA loans much more quickly. So great point that you brought up and answered yourself. I love that feedback.
Cool. Great. Great. Well, let's jump into some of the other questions we have here.
Mhm.
So we have masks for the homeless in Jersey City. There we go.
Noble,
Can you,
noble project. I love it.
there you go. Can you speak on how to respond to summary judgment, please? I didn't see
It's
anything on your website about it. How common is this?
a George question.
I think that's a question for me. Yeah. So if you are getting a summary judgment, so probably what's happened. So the debt lawsuit begins with a complaint and summons in most states. So you'll be served a complaint and summons. Oftentimes you get handed those documents in person. A lot of people search what to do. They come to Solo, and if you are getting a summary judgment, you probably used our answer document to respond to the lawsuit, get that filed in court. And then what we recommend for most people, if you recognize the debt, if you agree that you owe like a portion of the debt, we usually recommend using our Solo Settle product to get that settled. And if you have, right, if you have like a ton of debt or like you have a bad debt to income ratio, definitely consider doing bankruptcy. And it looks like you probably used us to respond, and then you have received a motion for summary judgment. What that is a motion is just a document where one party in the lawsuit asks the judge to do something. You're just asking the judge to do something. In legal terms, you're asking them to move. And in this case, they're asking the judge to make a summary judgment. So to conclude the case early because the other person doesn't have a case. Right? So the collector's saying, you don't have a case, you should just lose practically automatically by the judge's decision. So what you need to do in that case is you need to respond with a counter motion opposing the summary judgment, and with that, probably attach a memo or like a memorandum to that memo, to the motion, and get that filed in court as well. So we don't have like a product that helps with that. You can, we do have content on our site about motions for summary judgment. Maybe just take another look on our site. Upsolve might have some info on that as well. And your court might have like a template that you could find that is a motion template that you could start with. Or you could just start by redrafting our answer document, repurposing it for responding to a motion for summary judgment. So that's the general idea. So if you don't want to lose the case, you gotta respond with an opposing motion to the summary judgment. It's pretty crazy in my mind. Like none of the cases where a consumer comes to us should be ruled on a summary judgment because you're saying that there's a clear dispute on the debt. So that's in summary, you just got to respond to the motion for summary judgment. But if you do owe the debt, again, we recommend that you settle or that you do something else that'll move your situation along, like doing bankruptcy. Anything you'd add on that, Ben?
No, I sent 2 articles in the chat while you were talking from our website that talks about wage garnishment, which you mentioned earlier, and like when bankruptcy does and doesn't stop that. And then I also sent an article on dealing with judgments in bankruptcy and what that looks like. So beyond that, I think George is the expert there.
Already love it. All right, we got another question from Cheswick. I've previously filed both Chapter 7 and 13 with attorneys. Will that experience significantly help pro se bankruptcy filing for Chapter 7 again?
Yeah, that's a great question, Cheswick. So it's not going to make it any easier or harder or more likely. Let me say this differently. It's not going to make it any more likely that your petition is accepted or rejected, as long as you're outside the allowable time frame. So there are times where you can't file post filing. So you can only file Chapter 7 every 8 years, for example. In terms of what you'll actually have to do, that prior experience will have made you more comfortable with the forms because you most likely saw those forms to at least sign them or enter information in them. And it'll also make you more comfortable with the supporting document requirements that you need, like your tax returns. So if you filed before, you're at least going to have that familiarity. And then a tool like Upsolves will kind of take you the rest of the way and I think make it kind of drop dead simple from that point on.
And Upsolve, the software specifically does Chapter 7, right?
It does. Yeah, we do not do Chapter 13 bankruptcies.
Right. Yep. So if you qualify for Chapter 7, yeah, definitely go on over to Upsolve and get that done. How common is it to? Do you have an idea of how common it is to file bankruptcy multiple times? Figure this.
Uh,
Figure Tesla's a bit of an expert at this point.
yeah,
Done
yeah.
a few
No,
times.
this is another sad but true question. So our users don't usually end up filing more than once. We've only seen a few of them do this. Chapter 13 bankruptcy filings, there are, if I remember correctly, on average, people file 4 times before they get a discharge. And the reason for that is that if you really need bankruptcy, something that just kind of kicks the ball down the road, like Chapter 13 does, is not going to help you very much. Like you're going to end up in a position in a few years where you haven't really been able to keep up with your payment plan, or you're in more debt now. And so it kind of snowballs and you don't get out. And what I see happen a lot is there's a lot of like very predatory Chapter 13 marketing that says like, hey, get out of debt for $400 with this plan. Sure, it might cost way less than working with an attorney to file Chapter 7, but if you never get out of debt and you have to do it 4 times, it doesn't matter. So definitely, if you are really struggling with your debt, I would consider whether Chapter 7 or Chapter 13 is the better option for you.
Yeah, I think in most people's mind, I feel like in the like for like a regular person on the street, when they think bankruptcy, they think it means Chapter 7.
Yep.
And then when
Yeah.
people do Chapter 13, they
Go
think
to
they're getting
lawyers.
Chapter 7.
Yep, 100%. Yeah, so they're like, "Oh, my debt goes away," and we're like, "Well, yeah, but after you make
Right.
these payment plans for the next
So,
3 years."
so you said Chapter 13, people oftentimes file 4 times before they get a discharge. What do you mean by discharge? That means before,
Yeah.
not before their Chapter 13 is accepted, but you mean on the, yeah,
So
what do you mean by discharge here exactly?
when I say discharge, what I mean is the debt that you have right now is gone. So you either get that to go away through doing a payment plan in a Chapter 13.
I
So,
see.
2, 3 years later, you've paid it down according to that plan and it's gone, it's
I see.
discharged. Or with a Chapter 7, let's say you have the $60,000 in debt that I have, your discharge is the judge giving you a legal piece of paper that says, hey, this debt that existed doesn't exist anymore. You don't have the responsibilities of it. It's just gone.
Right. So you're saying that some people will file Chapter 13 bankruptcy 4 times
Yep.
before they complete the
Complete their
payment
payment
plan.
plan. Yep. And the debt's
Well,
gone.
that's gnarly. Yeah. Okay. Well, yeah, definitely. So you definitely
And
want
that
to
data
be
is
aware of what you're getting into.
and that data is a little old. It might be different than that now. I know it was in like 2018. It was around 4 times on average.
Oh, yeah. Well, if you really need it, still a good option, right?
Yeah, no, it definitely can be. If you're somebody that's really like pull myself up by my bootstraps, but I need a little bit of help because my bootstraps are not long enough kind of person, like Chapter 13 can be a good option as long as you can stick with that payment plan. My personal opinion, though, is that something like a debt management plan ends up being a little bit less onerous and a little bit less damaging to your credit, and it's almost the same thing. So again, if you're curious which ones are right for you, we also have a tool on our website that helps you figure that out. Literally on our homepage, upsolve.org, answer a few questions, and it'll help you figure out if it should be conventional bankruptcy, settlement, debt management, or something else.
Right. And this is a really sweet tool, folks. You should definitely go check that out if you're considering about what the decision to make here. So, Mystic in the Burbs, what are common mistakes people make when filing Chapter 7 for themselves?
Yeah. Hmm. So mistakes that I made was using the wrong forms. I just recorded a podcast on this morning. It's over on the Upsolve channel on YouTube. The thing that's so hard to know when you're filing is whether or not you need additional state forms. Because if you go to like the federal bankruptcy website, there's literally a list of like, I don't know, 200 forms, and you only need 14 of those, I believe. And so figuring out which ones apply to you can be tricky. Also, if you live in a state that has its own individual forms, those forms are on that state court's website, separate from the federal website, and you don't need all of those either. So finding which ones you need, very tricky, way too tricky, shouldn't be. That's why we have state filing guides for every state on Upsolve's website. That's thing one. So having the wrong forms. Thing two is not reporting your income correctly. It's difficult to know what income matters and like which forms you're supposed to report it on, which income matters for the means test that you have to do to see if you're eligible for bankruptcy, and which income doesn't. and misreporting income can cause your case to stall. And then the next one is just not responding to notices properly. So not getting a notice from your trustee or looking out for it, not showing up to your 341 meeting of creditors, because it is a legal process. Like, it has deadlines, it has follow-ups that have to happen at certain times. And if you miss those, it can delay or cause your case to get thrown out.
Fantastic. Very good to know. So we got a question from Bo. How difficult is it to qualify for a Chapter 13? Also, will my child support payments be deducted from my income?
It's a good question. I am not a Chapter 13 expert, so the qualifications of it escape me. Let me just look in a database here, 1 second. So you have to have regular income to support your repayment plan. There is a debt limit. So this is a 2022 number, so it might have changed since then. But your unsecured debt, so this is debt from things like credit cards or medical bills or personal loans, something not attached to property, has to be less than $465,275, which hopefully it is. That would be a rough situation to be in. And your secured debts, which would be things like your mortgages or car loans, have to be less than 1.4 million. You have to be up to date on tax filings, which is also a requirement for Chapter 7 bankruptcy. You can't have had recent bankruptcies, so Chapter 13 in the last 2 years. Hey, that's the number I was looking for earlier. Or Chapter 7 in the last 4 years. And then you have to do a credit counseling course, which is also a requirement for Chapter 7. So too long, didn't read version of this, as long as your normal debt is less than 465,000 and your house and car debt is less than 1.4 million, and you're up to date on your taxes and haven't filed bankruptcy recently, you should be able to qualify for a 13.
You said the unsecured debt has to be like
Yeah.
below 400,000 or so, you said.
Mm-hmm.
What happens if it's above 400,000? Does that mean you do Chapter 7? Or does that mean you can't? What happens then?
That's another great question. So I am not sure. I'm not sure if your debt is too high. You might segment some of it. It might be like some portion of it can be discharged and some portion can't. But it's not something I know much about. I apologize.
That's fascinating. I guess I expected the requirements to be reversed on that one.
Yeah, I would
Right.
thought
It was
so
saying
too.
if you have over $400,000, you can't file Chapter
Yeah.
7 or Chapter 13. Right. Yeah, that's interesting. Um, okay. And then, of course, you could still qualify for Chapter 7 in that case,
Yep.
potentially, if you meet
Correct.
the other requirements. Um, Fascinating. Yeah. Well, if you have over $400,000 in credit card debt, let us know.
Yeah.
We'd
Yeah. I
we'd be
hope you
curious to
don't.
see what
But if you
happens.
do, we'll find some super inspiring recovery story for you.
Exactly. Exactly. Uh, okay, let's see. Next, we have time just for one more question here, folks. And let's see.
Yeah. I did some follow-up
Yeah,
research. It looks like you're just straight up not eligible if it's over 465. Like, your only option is Chapter 7 in that instance.
right. I guess that's kind of a nice thing, right? Because they're presuming that you really need like an actual
Yeah,
discharge.
like a real fresh start. Yeah, definitely.
Right. Uh, okay, let's see. We have one more question here. I'm also curious to know how bankruptcy, this is from Cheswick, yeah. I'm also curious to know how bankruptcy judges view pro se filers. It's very difficult for me to
Hmm.
imagine pro se Chapter 13 filing because my 13 attorney had significant communications with the trustee.
Yeah, that's a really good point. So you are more invested in your case than most lawyers are going to be, right? So like, the odds are, if you're looking at your mail, if you're looking at any notices, you're going to see when the trustee contacts you and you're going to try to contact them. So you're always going to have more incentive to do that than a lawyer does. In terms of how judges view it, um, every judge is different, and in reality, actually, you'll probably never really see a judge in your case, and they may not even really see your petition. They kind of just rubber stamp the things the trustees give them once the trustees approve it. So if you do have to work with a judge, or if a judge is actively reviewing your case, usually pro se filers in court, unless you have like a super mean judge, get a little bit of leniency that attorneys don't get. Like if you put your name in field 1 instead of field 2, the judge or the clerk that's looking at it might just say like, oh, I know what this is. Whereas if an attorney does it, they're going to say like, hey, you're an attorney, you shouldn't be doing this. So they, in short, like they don't dislike pro se filers necessarily, and you don't get more scrutiny than you would with an attorney. I see a note from Cheswick down here too on chapter 13. So your experience, Cheswick, saying like chapter 13 was awful, so many landmines and pitfalls, and the trustees being so watchful over the years. You got it after 3 years. Yeah, it is. It is really, really hard for some people. Like what you're saying really reflects the experience that a lot of Upsolve users have had. We have many, many people who went through several chapter 13s that they never were able to complete before they filed for chapter 7. So it's very uncommon, or very common, excuse me, that if you're really struggling, a chapter 13 isn't a good fit for you.
Right. Yes. Okay. Well, thanks for showing up, everybody. Ben, thanks so much for coming on
Yeah, of
to
course,
the
anytime.
show. Very glad to have you on.
Happy to be
If
here.
people want to learn more about you and Upsolve, where do they go?
Yeah, upsolve.org. Our tools are right on our website. Our Learn Center has over 1,700 articles on various debt topics. You can also check us out on YouTube. We're at Upsolve BK. And actually, it might just be at Upsolve. Hold on, let me find out now. I think I was able to change it finally. We're at Upsolve. Yay. So find us on YouTube. We have all sorts of videos. I do FAQs. We also do our live webinars on Monday night answering bankruptcy specific questions. And I would love to see you there.